Having discussed these general principles, it may be instructive to consider how they apply to real-life situations. So let's continue the following scenario. A newspaper, say in a religiously conservative country, publishes a list of names of women who are alleged to have had abortions. The information comes from medical records that have been leaked to the paper by a staff member in a clinic who is opposed to abortion on religious grounds. A number of the women whose names are published sue the newspaper for violating their right to privacy. How should we approach this case? Well, following the three-part test, we should first look at whether there may be a legitimate aim in pursuit of which the newspaper's right to freedom of expression may be restricted. The protection of the rights of others is mentioned as one such legitimate aim, and this would include the protection of the right to privacy of the women concerned. So, there would be a legitimate aim. The second question to ask would be whether there is a law that protects the right to privacy, and whether that law is sufficiently accessible and clearly worded so that the newspaper would have been able to foresee that by publishing the women's names, they might open themselves up to a lawsuit for violating their privacy. The third question to ask is whether the restriction is necessary and proportionate. In answer to this question, more needs to be known about the motives of the newspaper, the situation of the women concerned, and the broader political context of the case. The fact that one of the women is a prominent politician who is well known for her anti-abortion views might be an important factor in this. Now let's look at a second scenario. A newspaper publishes details of the business interests of the Minister of Defence. He owns a shoe factory. He takes the paper to court for breaching his privacy, and he says that his business dealings are his own private affairs. What do you say? Again, this needs to be approached following the three-part test. The first and second parts of this test are the same as in the previous scenario. The legitimate aim protected would be a minister's privacy, and there needs to be a clearly and precisely formulated law under which the minister could sue. And, as under the previous scenario, the third part of the test requires a lot more context. For example, while a shoe factory would appear to be innocuous and have nothing to do with his role as a government minister, it may well be that the factory supplies shoes to the army, and that then raises important questions as to whether a minister should be allowed to profit from business deals with the government department he is responsible for. The previous two scenarios were pretty straightforward. Now let's look at a third. An opposition organisation publishes a series of political cartoons about the president on its website. He's portrayed as an alcoholic and a would-be ruler for life. The prosecutor initiates a criminal inquiry, claiming that the cartoons have defamed the president. If you were the judge, what view would you take? Again, the three-part test will need to be followed. The first question will depend on the laws in force in the country, but let's assume that it is a criminal offence, as it is in many countries, to insult the president, or to insult anyone for that matter. Assuming that the laws in this are clear, that then clears the first hurdle. But what about the second question? Does a restriction like this pursue a legitimate aim? Do you have a right not to be portrayed as an alcoholic? If not, what other legitimate aim would be served by the prosecution? Maintaining national security? Any other legitimate aims? This question would need to be very carefully considered. And how about the third hurdle? Would the prosecution be strictly necessary in a democratic society? We have seen how important the right to freedom of expression is in democracy, and particularly with regard to political speech. Bearing that in mind, will it be really necessary to prosecute? Or would an alternative course of action be for the president to simply respond to the criticism? Respond to speech with more speech? I don't intend to give you the answer here, but these three scenarios hopefully serve to illustrate the approach that international human rights law requires to be taken with regard to restrictions on the right to freedom of expression. I hope you found this a useful introduction to the underlying principles and sources under international human rights law for the protection of the right to freedom of expression. This lecture forms part of a series of lectures that accompanies a manual on defamation law under the European Convention on Human Rights, published by the Media Legal Defence Initiative and the International Press Institute. It can be downloaded from our website www.mediadefence.org, and I do recommend that you do this and that you use the manual as a reference guide. Do also check out the other lectures, which can be found on our website as well. Thank you for your time.